Karen called cops for parking on my own lawn. Didn't know I'm the judge handling her divorce next week. Hello, everyone. Before we begin today's story, I have a small request. Please let me know where you are tuning in from today. Leave the name of your city or country in the comments section below. Thank you very much. Now, let's get back to the main character of the story. You don't really know a person until you see how they behave when they think they have all the power. That sentence kept echoing in my head the morning a police cruiser rolled onto my property because my pickup truck was parked on my own front lawn. My name is Ethan Walker, and if you had driven past my house that Saturday, you probably would have assumed I was just another homeowner trying to finish a renovation before summer ended. The smell of freshly cut grass mixed with damp soil hung in the warm air after an overnight shower. Stacks of lumber rested beside my garage, and a rented utility trailer sat near the driveway while contractors replaced sections of cracked concrete. Since half of the driveway had been torn out, I eased my dark blue Ford F-150 onto the wide stretch of grass that belonged entirely to my lot. It wasn't elegant, but it was temporary, practical, and completely legal. I had barely stepped out of the truck before I heard the sharp click of heels striking the sidewalk. "Excuse me," a woman's voice called out with the confidence of someone who never expected to be ignored. I turned to see a blonde woman in expensive sunglasses marching toward me from the house across the street, holding her phone up as if she were documenting a crime scene. "You can't park there," she announced without introducing herself. I looked around for a moment before realizing she meant my own yard. "Actually," I replied calmly, "this is my property." She laughed, not because my answer was funny, but because she had already decided it couldn't possibly be true. "I've lived in this neighborhood for 6 years," she said. "I know the HOA rules better than you do." I smiled politely and explained that my driveway was under construction and that my contractor had suggested moving the truck onto the grass for the day. Before I could finish, she interrupted me again. "The HOA will fine you for destroying community landscaping." I glanced down at the lawn I'd spent years maintaining myself, and then back at the woman accusing me of damaging it. "This landscaping isn't maintained by the HOA, I said. "I pay for every inch of it." Instead of listening, she took several more pictures from different angles. The camera shutter kept clicking while she circled my truck like she was gathering evidence for a courtroom. Then she folded her arms and smiled in a way that suggested she was already imagining how this story would end. "I'm Melissa Crawford," she finally said, "and I don't tolerate people who think they're above the rules." "Nice to meet you," I answered. "I'm Ethan." She didn't ask my last name. She wasn't interested in who I was. She had already decided who I must be. Less than 5 minutes later, an HOA board member arrived in a golf cart after receiving what was apparently an urgent complaint. Melissa wasted no time pointing dramatically toward my truck while describing the situation with enough exaggeration to make it sound as though I'd driven through a public park. The board member asked whether the vehicle was on my property, and I simply nodded. He looked at the property survey stakes still visible from the construction work and quietly admitted that it appeared to be. Melissa's expression hardened immediately. "Then call the police," she demanded. "He's violating county ordinances." The board member hesitated, clearly unconvinced, but Melissa had already taken out her phone. I heard her calmly tell the dispatcher that a homeowner was illegally parking on protected landscaping and refusing to comply with neighborhood regulations. Every sentence sounded more dramatic than the last. I considered correcting her claims, but experience had taught me something valuable over the years. People often reveal far more about themselves when you don't interrupt them. About 15 minutes later, the distant sound of a siren drifted through the neighborhood before a patrol vehicle slowly turned onto my street. Several neighbors wandered onto their porches, pretending to water flowers or collect mail while quietly watching the scene unfold. Melissa stood straighter with every passing second, wearing the unmistakable expression of someone convinced that official authority was about to validate every assumption she had made. She slipped her phone into her purse, crossed her arms with complete satisfaction, and smiled as the police cruiser rolled to a stop beside my lawn. In that moment, she truly believed she had already won. The first officer stepped out of the cruiser with the kind of calm professionalism that comes from answering hundreds of neighborhood disputes every year. He adjusted his radio, glanced at my truck, then looked at the construction materials stacked beside my garage before walking over with an easy smile. "Good morning," he said. "I am Officer Daniel Ruiz. We received a complaint about an illegally parked vehicle. Good morning, officer, I replied. I am Ethan Walker. I believe this will be easy to clear up. Before I could say anything else, Melissa hurried between us as though she had been waiting her entire life to deliver an opening statement. Officer, he is destroying protected landscaping, violating HOA rules, and refusing to move his vehicle, she declared, pointing dramatically toward my truck. He was told multiple times that he cannot park there. Officer Ruiz nodded politely without reacting to her tone. Sir, is this your property? He asked me. Yes, it is. Do you have identification with you? Absolutely. I handed him my driver's license while he took a slow look around the property. The fresh concrete forms, orange safety cones, and contractor markings made the situation fairly obvious. Another patrol officer, a younger woman named Officer Emily Carter, walked over to inspect the area more closely while Ruiz radioed in my information. Melissa remained unusually quiet for almost 10 seconds before beginning another round of accusations. He keeps acting like he owns the neighborhood. That truck has been sitting on the lawn for hours. If you let people do this, everyone will start parking wherever they want. Officer Carter looked down at the property line markers that were still visible near the sidewalk. These survey stakes were placed recently? She asked. Yesterday afternoon, I answered. The contractor wanted the exact property boundaries confirmed before replacing the driveway. She nodded thoughtfully and walked several yards across the lawn, comparing the stakes with the county parcel map displayed on the tablet attached to her patrol vehicle. Melissa noticed the officers were taking their time instead of immediately ordering my truck to be towed, and her confidence slowly turned into impatience. Why are we even discussing this? She demanded. It is obviously against the rules. Officer Ruiz answered with the same measured tone. We are determining whether any laws have actually been violated. Melissa folded her arms. The HOA handbook says vehicles cannot be parked on lawns. I finally spoke again. The HOA handbook is a private community document. It is not a criminal statute. She rolled her eyes so dramatically that even one of the neighbors quietly looked away. So now you are a lawyer too? She asked with a sarcastic laugh. No, I replied evenly. I simply believe it is important to distinguish between association policies and county law. A few neighbors had now gathered along the sidewalk, pretending to chat while watching every word. One older gentleman across the street gave me a small nod as though he suspected this situation had gone much farther than it ever should have. Officer Carter returned after checking the digital parcel records. Everything appears consistent, she told her partner. The vehicle is entirely inside the owner's property line. Ruiz thanked her before turning back to Melissa. Ma'am, based on what we have verified, the truck is parked on private property owned by Mr. Walker. Melissa immediately objected. That does not matter. It still looks terrible. The neighborhood has standards. That may be something for your homeowners association to discuss. Officer Ruiz answered. It is not something we enforce unless an actual law has been broken. Instead of accepting the explanation, Melissa became even more determined. She opened her purse, pulled out a thick binder filled with HOA documents, and flipped through page after page until she found a highlighted section. Holding it up like a piece of courtroom evidence, she began reading portions aloud while emphasizing every sentence that she believed supported her position. Officer Ruiz listened respectfully before saying, Ma'am, I appreciate that you care about your neighborhood. However, homeowners association rules are generally civil matters between the association and property owners. They are separate from criminal enforcement. Her face flushed with disbelief. So you are just leaving? She asked. Unless there is something else requiring police assistance. Yes, he replied. I thanked both officers for their time, expecting the matter to end there. Melissa, however, stared at me with the unmistakable expression of someone who had no intention of accepting defeat. As the patrol car slowly pulled away, she looked directly into my eyes and said, This is not over. If the police will not fix this, the HOA certainly will. I simply nodded, knowing that sometimes the loudest promises reveal far more than the quietest responses ever could. The neighborhood returned to its quiet rhythm the moment the patrol cars disappeared, but Melissa was clearly unwilling to let the morning end with an answer she did not like. While my contractors resumed measuring the driveway forms and the steady hum of a concrete saw echoed from the side yard, I noticed her standing on the sidewalk speaking rapidly into her phone. Every few minutes, she pointed toward my truck or waved one of the photographs she had taken earlier, as though repeating the same story louder would somehow change the facts. I went back to helping move several stacks of pressure-treated lumber into the garage, deciding that the fastest way to end an unnecessary conflict was simply to continue living my life. Around noon, my contractor, Mike Hansen, walked over carrying a rolled set of construction plans. "I have been doing this for 20 years, he said with a quiet grin. "I have seen neighbors complain about paint colors, fences, and mailbox heights, but calling the police because somebody parked on his own property is definitely a new one." I laughed softly. Every neighborhood has at least one person who mistakes confidence for authority. Mike nodded before returning to his crew, leaving me alone long enough to notice another unexpected visitor pulling into the street. This time it was not a patrol vehicle. It was the white SUV belonging to the Homeowners Association property manager. The woman who stepped out introduced herself as Rebecca Collins, and unlike Melissa, she immediately shook my hand before asking any questions. "Mr. Walker, I received an urgent complaint requesting an emergency compliance inspection," she explained. "I would like to understand the situation from both sides." I appreciated the straightforward approach and walked her around the property, showing her the driveway renovation permit posted near the garage, the contractor's schedule, and the county survey markers that remained in place. Rebecca carefully reviewed everything without interrupting. Then she asked one simple question: "How long will the truck need to remain on the lawn?" "Probably until Monday afternoon," I answered. "Once the new concrete cures enough for light traffic, it will be back in the driveway." She made a brief note on her clipboard and thanked me. Before leaving, she quietly admitted that temporary construction conditions were usually handled with reasonable discretion. I thought the conversation had gone well until Melissa hurried across the street carrying the same thick HOA binder under one arm. "You cannot just leave," she called after Rebecca. "He is violating multiple sections of the community standards." Rebecca remained polite. "I have inspected the property, and I will complete my report after reviewing the governing documents." Melissa immediately launched into another detailed speech, quoting individual rules while emphasizing words like appearance, neighborhood values, and enforcement. Rebecca listened patiently before reminding her that every complaint required factual verification, not assumptions. Melissa did not seem satisfied. By late afternoon, I began receiving curious looks from several neighbors walking their dogs. One younger couple asked whether I had really refused to cooperate with the police. Another neighbor quietly mentioned that an online neighborhood discussion page had already filled with comments claiming I had ignored multiple warnings from law enforcement. I realized then that the story spreading through the community was no longer based on what had actually happened. It had become a version carefully shaped by someone determined to be right. Rather than responding online or knocking on doors to defend myself, I simply continued documenting everything. I saved photographs of the construction progress, copies of my permits, and even the timestamps showing exactly when the driveway work had begun. Years of professional experience had taught me that accurate records often spoke far louder than emotional arguments. As the afternoon sunlight stretched long shadows across the yard, my phone vibrated with an email notification from the Homeowners Association. The subject line read, "Notice of Compliance Review." According to the message, a formal hearing had been scheduled for the following week to address multiple complaints regarding improper vehicle placement, alleged property misuse, and failure to comply with community standards. Reading the list, I almost smiled because nearly every allegation described events that objective evidence could easily disprove. Still, I accepted the meeting without hesitation. Rules deserve to be followed, but they also deserve to be interpreted honestly. Across the street, Melissa watched as I calmly closed the email and slipped my phone back into my pocket. She seemed almost disappointed that I had not reacted with anger or frustration. What she could not understand was that panic rarely improves the truth. Patience does. And sometimes the people most eager to create an official record forget that official records have a habit of preserving every mistake they choose to make. Monday morning arrived with the clean scent of fresh concrete curing beneath the summer sun, and for the first time in days my truck was back where it belonged. The driveway crew had finished ahead of schedule, the construction equipment was gone, and the lawn looked exactly as it had before the entire dispute began. If someone had driven through the neighborhood that morning, There would have been no sign that anything unusual had happened. Yet I knew the real conflict was only beginning because the Homeowners Association hearing was still scheduled for Wednesday evening. I spent the next 2 days exactly as I always did, following my normal routine without giving the neighborhood gossip another thought. Late Tuesday afternoon, as I was organizing paperwork in my home office, my cell phone rang. The screen displayed a familiar number that I had seen hundreds of times over the years. I answered in the same calm voice I always used. "Good afternoon." "Good afternoon, Judge Walker," the woman on the other end replied. "This is Laura Bennett from the Court Administration Office. I wanted to confirm next week's civil docket and verify that your schedule remains unchanged after the holiday weekend." I glanced at my calendar while opening the electronic case schedule on my computer. "Everything looks correct from my end," I answered. "Please keep the calendar as it is unless there is an emergency reassignment." "Thank you, Your Honor." There was also one additional filing added this morning. "The updated documents have already been uploaded for your review." "I appreciate it. I will look through everything this evening." We exchanged a few routine scheduling details before ending the call. It was an ordinary administrative conversation, the kind that happened regularly and carried no special significance. Unfortunately, ordinary conversations have a way of sounding mysterious when someone only hears a few isolated sentences. My office window happened to be open because the weather was unusually pleasant, and while I was placing my phone back on the desk, I noticed movement outside. Melissa was walking along the sidewalk with her small dog, slowing her pace as she passed my property. I doubted she had heard much, but she had clearly noticed enough to become curious. She glanced toward the open window for a brief moment before continuing down the street with an expression that suggested she was trying to solve a puzzle. The following afternoon, while I was trimming a few shrubs near the front porch, she approached the property line again. This time her tone was noticeably different. It was still confident, but the sharp edge from the weekend had softened into cautious curiosity. "Busy week?" she asked. "Fairly busy," I replied with a polite smile. "It usually is." She nodded, as though waiting for me to volunteer more information. When I did not, she continued. "I heard you talking about court yesterday." "Did you?" I asked pleasantly. "Sounded important," she said. "Something like that." I returned to trimming the hedge, making no effort to expand the conversation. The silence seemed to frustrate her far more than any argument could have. She shifted her weight, looked toward my driveway, then back at me. "Are you involved in some legal business?" she asked. "You could say that." It was an honest answer without revealing anything unnecessary. She smiled confidently again, apparently reaching her own conclusion. "Well, I hope your lawyer is good," she said before turning to leave. I simply wished her a pleasant afternoon. As she walked away, I realized she had completely misunderstood the conversation she had overheard. She believed I was preparing for a legal dispute of my own rather than handling professional responsibilities. I made no attempt to correct her assumption. There was no reason to discuss my career with someone I had met only a few days earlier, especially while an unrelated homeowners association review was pending. That evening, I gathered every document connected to the construction project into a single folder. Property surveys, contractor permits, county inspection approvals, dated photographs, email correspondence with the association, and copies of every notice I had received were organized carefully in chronological order. Good documentation had always been one of my strongest habits because facts rarely became weaker when preserved accurately. Before closing the folder, I noticed the updated court calendar that Laura had referenced during our phone call. I reviewed the week's schedule briefly, confirmed the hearing times, then placed the file neatly inside my briefcase. Across the street, Melissa stood on her porch talking with another neighbor while occasionally glancing toward my house. She looked completely satisfied, almost relieved, as though she believed the coming days would finally prove everything she had been claiming since Saturday morning. She had no idea that the smallest misunderstanding she had made all week was also the one that would eventually matter the most. Wednesday evening arrived with clear skies, warm air, and the quiet confidence that comes from knowing every document in my folder matched the truth. The Homeowners Association clubhouse sat near the front entrance of the neighborhood, a modest brick building with neatly trimmed hedges and rows of folding chairs already filling with residents curious enough to attend what many of them believed would be an unusually dramatic hearing. I parked my truck in the visitor lot, carried a slim leather folder under my arm, and walked inside without any sense of urgency. Melissa had arrived well before me. She sat near the front of the room with a large 3-ring binder, several printed photographs, and what appeared to be handwritten notes marked with brightly colored tabs. The confidence on her face had returned completely. She smiled politely at several board members while occasionally glancing toward me with the expression of someone who believed preparation alone guaranteed victory. Rebecca Collins, the property manager, welcomed everyone before explaining that the purpose of the meeting was to review a formal complaint regarding temporary vehicle placement during residential construction. She reminded everyone that the association would examine evidence from both parties before reaching any conclusion. That simple statement seemed almost to disappoint Melissa because she had expected immediate agreement rather than a review of facts. Once the hearing officially began, she stood and walked to the front of the room, carrying her binder like an attorney presenting a major case. One by one, she displayed photographs of my truck parked on the lawn, enlarging several images on a presentation screen so everyone could see them. She described the scene in dramatic language, insisting that I had intentionally ignored community standards, refused repeated requests to comply, and forced her to involve both the association and local law enforcement. Several residents quietly exchanged uncertain looks when they heard that version of events because many of them had witnessed at least part of the encounter themselves. Melissa continued speaking with complete confidence. She argued that allowing one homeowner to park on a lawn would encourage others to disregard neighborhood appearance standards. She emphasized words such as precedent, responsibility, and enforcement, repeating them often enough that they began to sound more emotional than factual. When she finally finished, Rebecca thanked her and turned toward me. "Mr. Walker, you may respond." I stood, placed my folder on the table, and began with the simplest fact. My driveway was under active replacement under a valid county permit. The temporary vehicle placement lasted less than 48 hours while fresh concrete cured according to the contractor's schedule. I handed Rebecca copies of the permit, contractor agreement, inspection schedule, and dated photographs showing the driveway excavation. She reviewed each page carefully before passing copies to the board members. I then presented the certified property survey identifying the exact lot boundaries. The survey stakes visible in Melissa's own photographs matched the official county records precisely. One board member leaned forward to compare the survey with the enlarged images displayed on the screen. Another quietly asked Rebecca whether the truck had ever crossed onto common property. "No," she answered after reviewing the documents again. Every photograph places the vehicle entirely within Mr. Walker's property line. The room became noticeably quieter. Melissa quickly opened her binder and pointed to another highlighted page in the association handbook. "The rules clearly state that vehicles should not be parked on lawns," she insisted. Rebecca acknowledged the provision before continuing to read the paragraph that followed. It explained that temporary exceptions could be considered during approved construction or maintenance when reasonable under the circumstances. Melissa blinked several times before reaching for another document, but the board had already moved to the next question. One member asked whether I had cooperated during the original complaint. Rebecca looked toward the incident notes attached to the file. According to the responding officers, Mr. Walker provided identification, property documentation when requested, and remained cooperative throughout the entire interaction. Another member asked whether any county ordinance had been violated. Rebecca answered directly. No violation was identified by law enforcement. I noticed several residents slowly lowering the copies of Melissa's complaint that had been distributed before the meeting. The story sounded very different now that every claim was being compared against objective records instead of assumptions. Melissa attempted one final argument, insisting that appearance alone justified disciplinary action regardless of permits or temporary construction. The chairman thanked her for expressing her concerns before announcing that the board would briefly recess to review the submitted evidence in private. As the members gathered their files and walked into the conference room, Melissa remained standing beside her chair, still convinced that somehow another rule, another technicality, or another accusation would restore the outcome she had expected from the very beginning. She had no way of knowing that before the week was over, a completely different document bearing a familiar name would change everything she thought she understood about the quiet neighbor sitting only a few feet away. The board members returned after only a few minutes, and the chairman thanked everyone for their patience before reading the decision. Based on the construction permits, the certified property survey, the responding officer's report, and the temporary nature of the driveway project, the board found no basis for issuing a violation. The complaint was officially dismissed, and the file would be closed without any fines or disciplinary action. A quiet murmur spread through the room as several residents nodded in agreement. Rebecca gathered the documents into a neat stack and reminded everyone that community standards existed to protect property values, but they also had to be applied with fairness and common sense. I thanked the board for taking the time to review the evidence objectively and began placing my paperwork back into the folder. Melissa remained completely still. For several seconds, she stared at the photographs she had printed, almost as if she expected them to change. Then she quietly packed her binder without saying another word. I left the clubhouse feeling relieved that the matter had been resolved professionally, and by the time I reached my truck, the warm evening air had already begun replacing the tension of the hearing with the familiar sounds of sprinklers and distant lawn mowers throughout the neighborhood. I assumed the entire episode had finally reached its natural conclusion. I was wrong. The following Friday morning, I arrived at the courthouse shortly before 8 o'clock, greeted the security officers, and walked through the employee entrance as I had done countless times before. My schedule was full, so I reviewed several case files in chambers before the first hearings of the day. During a short break between matters, my judicial assistant, Laura Bennett, entered with the calendar for the upcoming week. "Judge Walker," she said, placing a folder on my desk. "One additional family law hearing has been confirmed. The parties completed mediation unsuccessfully, so the court will proceed as scheduled next Tuesday." I thanked her and opened the updated file. As I reviewed the cover page, one familiar name immediately caught my attention: Melissa Crawford. I paused for a brief moment, not because of surprise about the legal matter itself, but because I instantly recognized the address listed in the file. It matched the house directly across from mine. The case involved her pending divorce, a matter that had been assigned through the court's standard administrative process well before either of us knew the other existed. I carefully reviewed the docket history and confirmed exactly what I suspected. The assignment had occurred weeks earlier through the normal random case allocation system. There had been no personal involvement in the assignment, no requests from either party, and no irregularities of any kind. Even so, professional ethics required complete impartiality, as well as careful consideration of any circumstance that could create even the appearance of a conflict. I immediately called Laura back into my office. "Please review the administrative ethics guidance with me regarding a recently discovered neighborhood acquaintance," I said. She understood immediately and retrieved the appropriate procedural materials. We discussed the applicable judicial standards, including disclosure requirements and the possibility of reassignment if either party raised a legitimate concern. Everything would be handled openly and according to established court procedures. Nothing about the homeowners association disagreement would influence my professional responsibilities in any way. That afternoon, while I was leaving the courthouse, I happened to notice Melissa entering through the public entrance with her attorney several yards behind her. She was focused on a conversation with the receptionist and never looked in my direction. From where I stood, I could hear only fragments of the discussion about confirming next week's hearing time before I continued toward the parking garage. 2 days later, on Sunday afternoon, I was watering newly planted shrubs near my front porch when a courier vehicle stopped across the street. The driver handed Melissa a large envelope that clearly contained official court documents. She thanked him, walked inside, and disappeared from view. About 20 minutes later, her front door opened again. She stepped onto the porch carrying several papers, reading each page carefully while slowly turning them over. Then everything about her posture changed. The confidence that had carried her through the police call, the neighborhood gossip, and the homeowners association hearing vanished almost instantly. Even from across the street, I could see her eyes stop on a single line near the top of the notice. She read it again, then a third time, before looking directly toward my house with an expression I had not seen before. It was not anger. It was realization. Printed clearly on the assignment order above the scheduled hearing date were the words identifying the presiding judge, followed by a name she finally recognized in full: Ethan Walker. Melissa did not come outside again that evening. Her porch lights remained on long after sunset, and every now and then I noticed the curtains shift slightly, as if someone inside was looking toward my house before quickly stepping back. I understood exactly what had happened. She had finally connected the first name she had heard during our conversations with the full name printed on the court assignment notice. Until that moment, I had simply been Ethan, the quiet neighbor renovating his driveway. Now she knew I was Judge Ethan Walker, and the realization had arrived entirely on its own without a single word from me. Early Monday morning, just as I finished collecting the newspaper from the front walk, I heard my name called from across the street. Mr. Walker. I turned and saw Melissa standing near the edge of her driveway. The confidence that had defined every previous conversation was gone. Instead, she looked unusually nervous, holding a folder against her side with both hands. I walked toward the property line, but remained on my side of it. "Good morning," I said politely. She hesitated for several seconds before speaking. "Could we talk for a minute?" "If this concerns neighborhood matters, certainly," I replied. "If it concerns your pending court case, I cannot discuss it." She blinked, clearly hoping the conversation would unfold differently. "I just wanted to explain what happened the other day," she said carefully. "I think maybe we got off on the wrong foot." I smiled courteously. The homeowners association already resolved that matter. She looked down at the folder in her hands before meeting my eyes again. "I did not know who you were." "That is true," I answered, "but it should not have mattered." She seemed unable to respond immediately because she knew the statement was accurate. Courtesy should never depend on someone's profession. After another brief silence, she lowered her voice. "About next week." I gently raised one hand before she could continue. "Please stop right there." She looked surprised, but I continued speaking in the same calm tone. "Anything related to your court matter must be handled through the proper legal process. I cannot discuss it outside the courtroom." She nodded slowly, embarrassed. "I understand." "Thank you," I replied. "Have a good day." I returned to my house without another word, not because I was upset, but because maintaining appropriate boundaries was part of my responsibility. Later that afternoon, after arriving at the courthouse, I documented the unexpected neighborhood contact exactly as judicial ethics required. I also informed the appropriate administrative office that I had recently become aware one of the parties assigned to an upcoming case lived across the street from me. Transparency mattered. Even when no actual conflict existed, proper disclosure protected both the integrity of the court and the confidence of everyone involved. Before the end of the day, both attorneys received formal notice that a neighborhood acquaintance had been identified after random assignment of the case, and that any concerns regarding recusal could be raised through the established legal process. Everything was placed on the record openly. Nothing was hidden. Nothing was handled privately. Tuesday morning arrived, and the courthouse followed its familiar rhythm of security screenings, attorneys reviewing files, and clerks organizing calendars. As I reviewed the docket one final time, Laura informed me that neither attorney had filed a motion requesting reassignment. The case would therefore proceed under the normal rules with full disclosure already documented. Shortly before the afternoon session began, I stepped into the hallway outside the courtroom. Melissa sat quietly beside her attorney, no longer projecting the certainty I had seen during the homeowners association hearing. Across from her sat her spouse and separate counsel, both focused on reviewing documents. Melissa looked up briefly as I passed, then immediately lowered her eyes without saying a word. That simple gesture said more than any apology could have. She now understood that every assumption she had made about me had been based entirely on appearances. More importantly, she had begun to realize something else. The authority she had tried so hard to borrow by calling the police and threatening rules was insignificant compared to the responsibility carried by someone whose duty was to follow the law without favoritism. And in just a few minutes, everyone in that courtroom would see whether I could separate a difficult neighbor from the impartial judge I had sworn to be. The courtroom settled into silence as everyone rose when I entered. I took my seat, reviewed the case file one final time, and looked across the room with the same deliberate focus I gave every matter before the court. The names, the documents, and the legal questions before me were the only things that mattered. Personal impressions had no place on the bench. After everyone was seated, I began with the standard opening remarks before addressing an issue that deserved complete transparency. "Before we proceed, I said. The court will place one matter on the record. After this case was assigned through the court's standard random assignment process, it came to my attention that one of the parties resides in my neighborhood. The court disclosed this information to counsel immediately upon discovering it. Neither party has filed a motion requesting reassignment, and the court is satisfied that it can remain fair and impartial throughout these proceedings. If either attorney wishes to address this issue now, the court will hear you. The room remained quiet for several seconds. Melissa's attorney stood first. Your Honor, after discussing the disclosure with my client and reviewing the applicable standards, we are prepared to proceed. The opposing attorney nodded. The other party is also prepared to proceed, Your Honor. I thanked both attorneys, and with that single exchange, the matter was resolved exactly as procedure required. No secret conversations, no special treatment, no shortcuts, only the record. As the hearing moved forward, both sides presented financial documents, testimony, and proposed agreements regarding property division and future obligations. I listened carefully, occasionally asking questions to clarify specific facts or confirm dates contained within the exhibits. Every ruling on evidentiary issues was based on established rules, and every decision was explained clearly so that both parties understood the reasoning behind it. Several times I noticed Melissa glance toward me before quickly returning her attention to the documents in front of her. There was no hostility in her expression anymore. Instead, there seemed to be genuine uncertainty, as though she was waiting to discover whether the fears she had created in her own mind would become reality. They never did. When her attorney objected to one document, I considered the legal arguments from both sides before sustaining the objection because the evidence did not satisfy the required foundation. A short time later, when the opposing attorney raised a different objection during Melissa's testimony, I overruled it because the testimony was directly relevant and properly presented. The rulings favored neither side consistently because they were never supposed to. They favored the law. As the afternoon continued, the atmosphere inside the courtroom became noticeably calmer. The attorneys adjusted their presentations to focus more carefully on verified facts rather than assumptions, and both parties answered questions with increasing precision. By the time closing arguments concluded, the emotional tension that often accompanies family law cases had given way to something more productive, a clear record supported by evidence instead of speculation. I reviewed my notes carefully before delivering the court's findings. Every conclusion referred back to testimony, financial records, statutory requirements, or applicable case law. I explained why certain requests were granted, why others were denied, and how the final decision reflected the evidence presented during the hearing. The explanation took time because every significant issue deserved a reasoned answer, not simply a conclusion. When I finished, I looked at both parties equally. The court expects all provisions of this order to be followed in good faith, I said. Compliance with lawful orders protects everyone involved and allows each party to move forward with certainty. Neither side celebrated. Neither side appeared devastated. That is often the nature of a fair decision in difficult civil matters. It rarely gives everyone everything they want, but it strives to give everyone what the law requires. As I gathered my files and prepared to call the next case, Melissa stood quietly beside her attorney. For a brief moment, our eyes met across the courtroom. She gave the smallest respectful nod before leaving through the same public doors she had entered earlier that afternoon. There was no attempt to speak with me, no request for a private conversation, and no effort to revisit the events from our neighborhood. She now understood that the greatest authority in the room had never been the title printed beneath my name. It had been the discipline to treat every person fairly, including someone who had once assumed I deserved none at all. Life in the neighborhood became remarkably quiet after that week, almost as though the entire community had silently agreed to return its attention to the ordinary things that actually mattered. Lawns were mowed, children rode bicycles along the sidewalks, delivery trucks came and went, and my newly completed driveway blended into the rest of the street as if the construction had never happened. Yet beneath that ordinary routine, something had changed. A few days after the court hearing, the Homeowners Association distributed a brief community bulletin reminding residents that complaints should be supported by verifiable facts and that temporary construction projects would be evaluated with reasonable flexibility rather than assumptions. The notice never mentioned my name or Melissa's, but everyone who had attended the hearing understood exactly why the clarification had been issued. Rebecca Collins stopped by one afternoon while conducting a routine property inspection elsewhere in the neighborhood. She thanked me for remaining cooperative throughout the process and admitted that the board had also reviewed its internal procedures after the incident. They planned to encourage informal communication between neighbors before escalating matters into formal complaints whenever possible. It was a small policy adjustment, but sometimes small changes prevent much larger problems. Several neighbors who had quietly watched the original confrontation eventually introduced themselves properly. One elderly couple apologized for believing the rumors before learning the complete story. Another family admitted they had assumed the police must have found something wrong because they had seen the patrol cars parked outside my house. I told each of them the same thing. Rumors travel quickly because they only require confidence. The truth usually takes a little longer because it requires evidence. One Saturday morning, nearly a month after everything had happened, I was washing my truck in the driveway when Melissa walked across the street carrying a small potted maple tree. She stopped several feet away, careful to respect the property line that had unintentionally become so important during our first meeting. "Good morning," she said quietly. "Good morning," I replied. She held out the young tree. "I know this cannot undo anything, and I am not asking for anything in return. I simply wanted to apologize for the way I treated you before I knew you." I looked at the tree for a moment before answering honestly. "Thank you, but there is something more important than knowing what I do for a living." She lowered her eyes. "I know." I smiled gently. "Every neighbor deserves respect before you know anything about them." She nodded without hesitation. "You are right. I spent a long time thinking about that." I accepted the tree, not because an apology erased the past, but because sincere accountability deserves the opportunity to become something better. We spoke for only a few more minutes, and for the first time our conversation felt completely ordinary. There were no accusations, no raised voices, and no assumptions. Just two neighbors discussing landscaping and the unusually hot summer weather. As she returned home, I planted the young maple beside the edge of the new driveway where the old construction equipment had once been stacked. Every time I watered it over the following weeks, I was reminded how easily first impressions can grow into lasting misunderstandings when people choose certainty over curiosity. Looking back now, I sometimes think about how differently that Saturday morning could have unfolded. If Melissa had simply walked over and asked why the truck was on the lawn, the entire story would have ended in less than 2 minutes. There would have been no police response, no homeowners association hearing, no neighborhood gossip, and certainly no uncomfortable surprise when she later discovered the identity of the judge assigned to her case. But life has a way of teaching lessons through the paths we actually choose rather than the easier ones we ignore. The greatest irony was never that I happened to be the judge assigned through a random court process. The real lesson was that my profession should never have mattered at all. Respect is not something people earn only after revealing an impressive title. It is something every person deserves from the very beginning. My truck remained parked exactly where it belonged. My driveway served its purpose for years afterward, and the young maple tree slowly grew taller with each passing season. Whenever I looked at it, I remembered that justice is rarely loud, revenge rarely changes hearts, and true authority is measured not by how much power someone possesses, but by how faithfully they choose to exercise it with fairness, patience, and integrity. Justice is not loud. It is simply smart, patient, and inevitable.